Good evening and welcome back to No Kings on the Hill with Dr. Hill Law. We appreciate you joining us again tonight on this Wednesday evening. Joe St. Clair, my co-host, was not able to make it tonight, so it'll just be me. Tonight, I am diving into some of the most consequential legal and constitutional developments shaping the country right now, particularly the Supreme Court level and in Congress and throughout executive action, all through a constitutional and originalist lens. Before we get started tonight, make sure to visit our website at No Kings on the Hill with drhilllaw.com, where you can find the links to our YouTube channel and all of our social media platforms. Give us a follow so you don't miss any upcoming episodes. You can also sign up for free access to our weekly blog or choose from one of our 3 subscription levels to support the show. Subscribers get access to our Discord community, opportunities to engage directly with us, chances to be a guest host, and even vote on future topics. Also, a quick reminder, we'll be broadcasting live for 3 days next week at CPAC on the Patriots Prayer Network. I don't have the exact times just yet, but I will be posting updates on our social pages and try to put it on our website as soon as those times are confirmed. We are expecting some major interviews, so you won't want to miss that. And obviously, we'll have some that hopefully are planned. Others will be on the fly type interviews. And while you're there, be sure to check out the other outstanding Christian conservative creators that are on our network. And now for a word from our sponsor.
Heard of Q Broadcast? It's taking the world by storm. People are cutting the cord to their high cable bills and moving away from streaming services like Netflix, Hulu, and others for something better. Q Broadcast. For just $60 a month, you'll get access to every channel you could ever want, including HBO, Cinemax, and Starz. And the best part? There are no contracts, no hidden fees, and you're free to cancel anytime. With Q Broadcast, you can enjoy streaming live TV, movies, and top series on up to 5 devices at once. Whether you're at home or on the go, Q Broadcast makes sure your entertainment is always at your fingertips. Imagine being able to watch all your favorite channels from anywhere, anytime, without any restrictions. We're talking about thousands of movies, hundreds of TV series, and a huge library of live channels, all in one place. And don't forget video on demand and pay-per-view events. Those are included at no extra cost, so you'll never miss a big event again. Now, take a second and think about your current cable bill. You're probably paying anywhere between $100 and $300 every month, locked into long-term contracts and hit with surprise rate increases. With Q Broadcast, that's a thing of the past. It's just $60 a month. No contracts, no extra fees, no hidden costs, and no price hikes. Why juggle multiple subscriptions like Netflix, Hulu, and cable when Q Broadcast gives you everything you need in one convenient package? People everywhere are switching to Q Broadcast, saving money and getting more content than ever before. So, what are you waiting for? Click the link in the description and sign up for Q Broadcast today. Just $60 a month, no contracts, no hidden fees. It's time to take control of your entertainment and start streaming smarter.
All right, so welcome back. I was just trying to double check something real quick. I'm trying to get my things to show up correctly on the screen, and it's still not showing. It's still showing backwards. Let me try one other thing real quick. I'm trying to get this stuff to edit correctly, and it's not. Keeps on showing backwards. Let me flip it. That's weird. Okay, that one did it. But my freaking other thing's still not showing correctly. Okay, I'm still trying to get my other sign. My browser. Nope, that's wrong browser. Let me see. Okay, let me try one other thing. I'm sorry, guys. Just take me a second. Just trying to get everything's kind of working a little different on this one. So there we go. It shows up a little different on this one, but no, that's actually going backwards. So let me transform it. Let me flip it horizontal again. Oh, that's weird. But at least you can see it now. All right, cool. That one's there. All right, let me get to my other browser. And let me flip that one horizontal again. There we go. All right, now y'all can see everything, right? Sorry about that, guys. Everything's a little different on this one than it is on my other stuff. So I'm going to go ahead and get started here now. Sorry about that. Just that little delay. So tonight, I want to step back for a moment and frame what we're really seeing unfold right now, not just in one case, not just in one branch of government, but across the entire constitutional system. Now, also, I guess I want to make sure y'all can hear me real quick. Let me unmute this. Okay, so y'all can hear me. Good. All right. Because if you look at the Supreme Court docket, if you look at what's happening in Congress, and if you look at how executive authority is being exercised today, there's a common thread running throughout all of it. Who actually governs in the United States? Now, this may sound like a simple civics question, but the truth is that the answer to that question has become murky over time. The Constitution is actually pretty straightforward. Congress makes the laws, the president enforces them, the courts interpret them. But obviously that hasn't really worked out most lately. And most importantly, coming with the Constitution is those powers are distinct from each other. They don't cross over. What we've seen over the past few decades is those lines begin to blur. One is biggest is with the judicial system. Congress cedes more power to administrative agencies. The executive branch uses those agencies to grow its power still further. The judicial branch then comes along and doesn't just check the power, it forces outcomes. And the result has been the concentration of power. Power that our founders were very deliberate about distributing. They created 3 branches, not 4. A constitutional republic where all powers resides in and is derived from we the people. So what makes this moment unique and why this episode is more important is that we're now starting to see that trend pushed back on. Judicially, not just politically. Look at immigration for one. All right, there's a couple other stuff but we're going to start with immigration. The question isn't whether the courts pick the right policy or the wrong policy. The question is, do the courts even have the power to countermand decisions made by Congress and given to the executive branch? When a law says that the president can exercise discretion, can the courts come in and take that power away from him? If you're an originalist, that's a problem. Also, engage in the comments. Let me know what y'all think. Immigration enforcement has historically been the purview of the political branches, the ones who are accountable to the people. The judiciary has long since taken it upon itself to review those decisions and order delays or block them altogether. So the question is that judicial oversight or is it judicial overreach? Judicial review or judicial activism? Well, now let's talk about election law. Election law doesn't get more black and white than this. Here we aren't talking about preferences. We aren't talking about outcomes. It's simple. We're talking about the plain text of the statute, the plain text of the Constitution. Congress has every right to determine when federal elections are held. That's the black letter Constitution law. So when arguments are made about whether ballots should be received by Election Day or days before, or whether they can be counted after Election Day, the question then becomes, are we within the law? What did Congress actually say in the text in the law that they wrote or the legislation? Not what we think is more convenient, not what newer systems allow, but what the statute requires is based on its plain text. That's it. And that's why textualism matters. We have to look at the text itself, because if we start letting courts or states pick and choose which statutory provisions to follow based on what's happened since the law was passed, we quickly replace the rule of law with, something else. Rules subject to interpretation. Judicial review or judicial activism, they are not the same thing. Now let's talk about one of the hottest button issues in law these days, parental rights. And obviously, wait for it, we've seen it coming up, and really the biggest is where parental rights are not a new idea. This isn't something that just started coming up. The Supreme Court has affirmed for decades that parents have a fundamental right to direct the care, custody, and control of their children. What we are seeing now is a direct attack on the scope of the right in public education. Should the government be able to make decisions about your children's gender, upbringing, or well-being without your knowledge? Or allow the child to make its own decisions? Should it serve as a partner or even a roadblock between you and your child? Let me know what y'all think in the comments. Obviously, I'm pretty sure I know what most y'all's answer is. Constitutionally speaking, that sounds like a problem. The whole point of our system is that your child's needs come first, but you get to decide what's best for your children, not the state. When we turn that system on its head for the right reasons, it still affects who holds the authority over your family. And that, my friends, is something we should care about. Okay, but how does that relate to, you guessed it, the administrative state? All right, which goes into what some call the fourth branch of government, is agencies have long been allowed to run wild, writing regulations, interpreting laws, and making policy with relatively little oversight. And courts allowed them to do that under legal doctrines like Chevron deference, which meant judges would rubber stamp agency decisions if the law was vague. Well, that's changing. As we know, almost 2 years now that the Chevron deference was repealed. The courts are now saying they will no longer interpret statutes, they'll interpret them themselves. And it has huge consequences because now we have to ask one question. When it comes to the law, who decides what the law is, the agency or the court? And who decides how much power they have? Should an unelected agency be able to determine the extent of its own authority? I mean, that seems like unchecked power to me. From an originalist view of the Constitution, the answer is clearly no. The courts are supposed to determine that. It is built into our constitutional system of separation of powers. Who has the power, who can delegate that power, and who is accountable for it? Which brings me to the final topic of the night, executive power. There's a debate going on about whether these so-called independent agencies are constitutional. If Article 2 of the Constitution gives executive power to one person, the president, how can we tolerate agencies that seemingly aren't under his control? Are they necessary to insulate these agencies from political pressure? Or are they inconsistent with the Constitution itself? You see where I'm going with this. When you start connecting the dots with immigration, with election law, with parental rights, it all goes back to one, and with administrative law, it all goes back to one area, with executive power in the administrative state. You begin to see the trajectory we are on. Either we return to our system of constitutional checks and balances, or we continue to blur the lines of separation until we no longer have any checks at all. And just so you know, I'm not saying that it's a conservative or liberal approach. I'm saying it's a structural thing. It's a constitutional thing. It's a textual thing, because no matter if you're left or right, we believe in limited government. And when we start pushing back on those limits, when we start expanding them, when we change the definitions, it impacts us all. So keep that in mind as we head into our discussion tonight. So I'm going to get into, it's not just about what they decided. It is about who gets to decide. It is about, what's at stake with the Constitution. Not just what the government can do, but who can do it and how much they can do it. So I'm going to get into the segments and kind of skipped. Like I said, originally I had planned on having two people. I planned on it being me and Joe tonight, but he ended up getting stuck traveling, so he couldn't really come into. He couldn't make it tonight, so it's just going to be me. And you're going to bear with me for a minute because I thought I'd got everything on it, but I guess I didn't. I got everything in here that I needed, but for some reason I'm missing my first segment. Okay, so I don't know why I'm messing this, but all right, let me get this in there real quick. Somehow it got kept out of, when I edited everything, I kept out segment 1 out of my script. So sorry about this, guys. Let me get in here real quick, and then I will get this fixed up. And that's it. Okay, so it'll take me about a second here. I just got to add it in. All right, that's what I needed. All right, so I'm going to take me a drink real quick, and then we'll get it started on segment 1, which is immigration and executive authority. All right, so let's start with immigration tonight, or more precisely, executive power over immigration. TPS is at the heart of tonight's immigration battle: temporary protected status. Congress established TPS as a temporary humanitarian program. Emphasis on temporary. It's not a political statement. That's the language of the statute itself. If nobody does, if you're kind of lost on where the TPS comes in, it was where President Trump had ended or had issued executive order to enter the temporary protective status of Somalians within the state of Minnesota. So that's where that comes at, which raises the constitutional question. When Congress delegates discretion to the executive branch, who decides how that discretion is used? Article 2 clearly states that the executive power shall be vested in the President of the United States, not in the administrative state, not in any other thing, not in some executive power, not in most of the executive power, but all of it. Alexander Hamilton reinforced this in Number Federalist 70, where he wrote, "Energy in the executive is a leading character in the definition of good government." Okay, so how does that work out in real life? Well, it means the president needs to be able to do his job, which, among other things, means controlling immigration policy as it relates to foreign policy and national sovereignty. This has long been established by the Supreme Court. They said in Knopf v. Shaughnessy in 1950, the power to exclude aliens is a fundamental sovereign attribute exercised by the government's political departments. Wow, they laid it down pretty heavily there. Immigration policy falls under the political branches, plain and simple. Yet today we see the courts trying to second guess not just whether the law was applied, but also how much discretion was exercised in applying it. This is a big red flag for originalists. The judicial branch does not run the executive. They interpret the law. James Madison even said this sort of power grab could lead to tyranny in Federalist Number 47. The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. So if we want to get mad about something, let's get mad that the judicial branch is trying to do the job of the executive. Now let's get on to election law. Oh, sorry, that's what I'm going to do. Okay. Now let's get on to segment 2, which is election law and statutory interpretations. Also, I will try to look. Well, the text shouldn't be backwards now from what I can see, unless it got all backwards again. Let me try to flip the camera. Why does it keep on ending up backwards no matter how I do it? Nope, that shows that it's right. Okay, but it's showing up backwards on there, which makes no sense. Like it shows, I don't get it. Yeah, it's showing up backwards on some of the stuff. It's showing forward on the other. I don't get it. Let me try something and see if it affects it or not. Try one other thing and see if that gets it. Or if it's just always going to be backwards for some reason. Because that's what's weird, is it shows that it's backwards on my side, which means it should be going forward on y'all's end. But yet somehow, if I transform it horizontally, see, it still ends up being, I'm not putting the camera backwards. So let me know if it's backwards on y'all's end still. Because if I have the camera mirrored, it's showing me that it's not backwards anymore. So let me know if y'all see it backwards or not, so I can make sure that it's fixed correctly. I'm trying to, for some reason, it's not working as good on this one as it was with my, as it was on my other end. Like everything else is forward, except for the image. Transform that horizontal. There we go. Yeah, now it's showing me everything's forward, but when I watch it on here, it's showing that it's, there we go. Now it's showing everything's the correct way. All right, looks like we got it fixed there. Sorry about that, guys. For some reason, it's a little different on here than it is with everything else. So hopefully let me know in the comments. Yep, okay, thank you. Yeah, I don't know why. It was showing that I was reading it backwards, so it should have been forward on y'all's, but it wasn't. It's weird. All right, so now let's go ahead and get on to segment 2, which election law and statutory interpretation. So now let's talk election law. When must a vote be counted? When must the vote be counted? Congress made election day 1 day. Clear as can be. It's in statute. So when states change, when ballots must be received after Election Day, are they enforcing the law or do they get to rewrite it? Textualism comes into play here. And the answer is no, they don't get to rewrite it. As Justin and Antonin Scalia stated, the law is what it says, not what Congress intended it to say. Translation, we don't get to decide based on new procedures or voting at our convenience. And this goes into two different cases. So there's the case of, I'm trying to remember the exact name on top of the tip of my tongue now, but it's Boston v. Illinois. And then there's another new case that's just going through, that's just being heard and was heard today. So I couldn't unfortunately get the downloads to it. But there was one that was just heard today in the courts. And both of them pretty much have to do with the states counting ballots after Election Day. Even though they were received by Election Day, they're still counting. Like Illinois counts up to like 12 days, counts mail-in ballots up to 12 days after the election, as long as they are postmarked by Election Day. But under the Constitution, that's not what it is. And then you also have Watson v. Republican National Committee, which is another in a different state where, again, it deals in with mail-in ballots where they're trying to count the ballots that are received past Election Day. Not postmarked, but received. So that's where these laws are going to help decide and could have a major effect or outcome on this election. The Constitution is clear on this in Article 1, Section 4. Congress has the power to prescribe the times, places, and manners of federal elections, which also goes into the SAVE Act and voter ID and proof of citizenship, which is well within times, places, and manner of federal elections. If Congress decides Election Day is day X, can states change that? It's not a matter of legislation, it's constitutional. Chief Justice John Jay's successor, Joseph Story, said the right of suffrage belongs to the people, but is regulated by law. That regulation must be compiled with, and the right must be exercised in the manner prescribed. It's simple, prescribed in the manner. Because the day you leave what is prescribed, you enter the word of subjective decisions, and subjective systems are chaos. Originalists know ambiguity is the enemy of order. And that's where we've seen a lot of problems with this, is they want to sit there and the states want to try to change it. So no. On a federal election, now state level elections, they can count it if they want to after the date of election. They can set those dates whenever they want to. That's states. That's separation of state and federal and state rights and everything. But for federal elections, for the presidency and for Congress, Congress sets those laws. And if election day is November the 5th, then everything has to be counted on November the 5th, not after November the 5th, not 12 days after it. Everything needs to be mailed in and received and counted by the day of the election, period. It's constitutional legislation, everything. There's no difference. There's no room in there textually for it. And that's what we've seen in a lot of these states is what we're seeing fought out in Boston, Illinois. Originally, it was ruled that Boss didn't have standing. The Supreme Court ruled on Boston, Illinois, and the evidence of him actually having standing to challenge the election laws in the state of Illinois. So they referred it back down to the lower courts to fight that out. We're still waiting to hear on that. The Watson v. Republican National Committee, that case was actually heard today. Unfortunately, the Supreme Court didn't have the transcripts up and yet or anything, so I didn't get to see how the hearing went. But hopefully we'll hear something before June on that. Now go on to segment 3, parental rights and education policy, which this one will be a whole lot longer. Let's talk about parents' rights. It's one of the most basic yet hotly debated issues in constitutional law today. The Supreme Court said it plainly back in Pierce v. Society of Sisters in 1925. The child is not the mere creature of the state. Can't you just picture a founding father nodding along to that one in the Roosevelt Room? That line may not be originalist icon Justice Clarence Thomas' actual mantra when he wakes up each morning, but it comes to capture an idea that many of us feel is foundational. The family is the bedrock of society. And when it comes to raising and educating children, the family comes first. The government comes second. The court confirmed as much in Meyer v. Nebraska. In Meyer, the court said the liberty of parents includes the right to direct the upbringing and education of children. So we know from the start of our constitutional republic that the state can have a role in education, but the state is not sovereign over the child. Wherein things get dicey today is when you see policies cropping up in schools that claim the power to make decisions about the identity, development, or well-being of a child without telling mom and dad what's going on, like in California, where schools can hide that a child is transgender, or they identify as a female instead of a male, or a male instead of a female, and not even tell the parents. And that prompts a constitutional question. If the state is not sovereign over the child, then where does the power of the state end and the power of the parent begin? As originalists, we should care about that line because our Constitution does not allow for general governmental authority over the family unit. James Madison said as much in Federalist Number 45. The powers delegated are few and defined. So if we're seeing the state assert power over our kids that overrides parents, where is that power coming from? I want to be careful with that, what I say about this, but I also want to be honest. There are historical examples of what can occur when the government supplants the family as the primary owner of children. Totalitarian governments have used control of education as a means to indoctrinate and control. Hitler placed special focus on children and their allegiance to the Nazi state. He stated, "He alone who owns the youth gains the future." Adolf Hitler once famously stated that. There's another Hitler quote that is attributed to him, but which historians say may not have been worded exactly as we use it today. It states, "The government, not the parent, has the ultimate power to shape and mold a child." I think you can see where I'm going with this. What we are doing today may not be Nazi Germany, but it's borderline. And the concept is the same. The moment the government begins to position itself between parent and child, no matter how benevolent the motives may be at that moment, we know where it's going to go. There's a constitutional problem in this because it becomes very difficult to draw the line at that point. The founders drew the line in favor of the family in our Constitution, not the state. The state may educate our children, but they don't get to control our children. It may establish standards, but they don't get to tell them what their religious purposes are. It may provide resources, but it may not take the place of the parent. The parent gets to decide how their child is raised. When we cross that line or start creeping toward it with public policy, we should at least question whether we are operating within our constitutional boundaries or have overstepped them. Because the core issue at stake here is whether we have a system of government where its authority is derived from families or whether we are shifting to a system where authority is derived from the state. And that is a difference that matters, not just from a legal perspective, but from a fundamental standpoint. And to help make this less abstract and more relevant to today, let's discuss how this issue is currently playing out both in the courts and in state legislation. As we mentioned earlier, Pierce v. Society of Sisters and Meyer v. Nebraska established this principle, but it hasn't stopped there. Fast forward to 2000 in Troxel v. Granville, the liberty interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. That's not an alternative right. That's written in the Constitution. Again, more recently in Wisconsin v. Yoder, the primary role of the parents in the upbringing of their children is now established beyond debate. Tell me we're not talking about deja vu here. When it comes to parental rights, we are not talking about a newly developed or emerging concept. Parents have a constitutionally protected fundamental liberty interest in the care, custody, and control of their children. Yet contrast that with what we're seeing right now at the state and local level. School districts in states like California are passing policies that prevent or discourage schools from informing parents about their children's decisions. These are children, not adults. We're seeing these laws particularly with issues that involve identity and student records. While many are framed around protecting student privacy, let's be clear about what these laws actually do. They raise the question of whether the government can claim a right of privacy on behalf of a child that excludes the parent. Likewise, we've seen litigation in state after state where school districts are putting into place policies that allow children to make decisions at school about their own lives without parental knowledge. I mean, come on. Do we let these kids to get to do this anywhere else? No. And now we're seeing these cases in the court system to determine whether those policies violate the Constitution. The reason this moment is significant is that this is just the tip of the iceberg. If you come from an originalist perspective, your fear isn't just about any one of these cases. Your fear is about the precedent that these types of cases set. If the government can have authority over a child on one subject without notifying parents, what is to stop them from doing that on other subjects? That is a question that our Constitution was designed to answer. If we take our cases seriously from Meyer all the way to Pierce to Yonder and to Truxell, then we know what that answer is. Parents aren't second class when it comes to the government. They're first. And any scheme that has the government ahead of parents is un-American and unconstitutional. Because once the state becomes the primary decision maker in a child's life, we are no longer debating education policy. We're redefining the structure of authority itself and the family. So we can't allow this stuff to keep going on. We can't allow it to keep happening. It's gotten ridiculous. We've seen it in California. Luckily, some states like Texas have put stuff up there to stop this. But it's the same thing with allowing these kids in these states to still give gender transition surgeries or start taking transitioning medications when they're little kids. How are they old enough to decide to literally mutilate their body and change the physical state of their body and cut limbs off when they're not even old enough to decide if they can drink or get a tattoo or go to war? I mean, come on, it's ridiculous. But this is what we're seeing happen. And it makes no sense at all how they even think or our government, our country is getting to that bad of a place. So yeah, we have seriously got to make some changes there. We have seriously got to get these changes fixed, get some stuff done, and make sure that our parents aren't losing their rights and still have the right to raise their child. Now, obviously, I'm not talking about where the child's being abused or whatever by the parent. I'm talking about where the parent is just trying to raise their child with good values and as a family unit, not allowing them to take every mental health issue as reality. I mean, children don't know what they want. What I said I wanted or believe or who I thought I was at 17 or 18 is not who I am today. So to allow a 9 or 10-year-old, a 12-year-old, or even an 17-year-old to literally cut limbs off and physically change their body, and we still don't even know the medical aspects and the types of effects these cancer, anything that could have on someone's body. I mean, because think about it. If women have low estrogen when they're older, they're higher risk for osteoporosis and a bunch of other stuff. Heart disease, same thing with men with lower testosterone when they're older. They're at higher risk for arthritis, being overweight, heart disease, diabetes, everything like that. So if we're sitting there taking little boys and girls and stopping their body from having the hormones that they're supposed to have at that age, think of the long-term effects over a whole lifetime versus just 20, 30 years of your life. I mean, how do we think that makes any sense? It just clearly doesn't. It's stupidity. It's ignorance. And honestly, I don't know very many people who say, oh, I chose to be trans. I chose to be this way. No, most of them say that's how they were born. So then shouldn't we be thinking of what's causing them to be born that way? Is it genetics? Is it a chemical imbalance? Is it a mental? I mean, because obviously there's something mentally wrong if you're wanting to literally chop your body parts off and you think you should be somebody else. I'm sorry, but you cannot be a unicorn. I mean, yeah, my little son thinks he's Sonic the Hedgehog sometimes, but he's 3 years old. So no, am I going to go have him turned into Sonic? No. All right, so let's get on to the fourth segment now, administrative state and corporate liability. So let's talk about what is potentially the most profound structural development of all administrative state. For years now, vast swaths of federal law have not been passed by Congress, but instead by administrative agencies. These agencies write regulations, interpret laws, and then police those interpretations. And for years, they did so under what was known as Chevron deference. Now, some people may not know what that is, but essentially, when faced with an ambiguous law passed by Congress, courts would defer to an agency's interpretation of that law as long as the interpretation was reasonable. Again, reasonable as a principle sounds great, but when viewed through a constitutional lens, you can see the problem because everybody's definition of reasonable is different. Article 1 of the Constitution leaves no ambiguity. All legislative powers herein granted shall be vested in a Congress. That is a Congress, not administrative agencies, not commissions, not the executive branch, not bureaucrats, especially not unelected bureaucrats, not lobbyists, none of that. But under Chevron, agencies have the power to interpret their own regulations, to decide what Congress actually gave them. That's not a housekeeping issue. That is something a whole lot more serious, and it's a constitutional one at that. As Chief Justice John Marshall explained in Marbury v. Madison, it is empathetically the province and duty of the judicial department to say what the law is. Administrative agencies are not part of the judicial department. So how can we have an administrative law justice? The executive branch is not part of the judicial department either. Only the courts have the power of judicial review, but administrative agencies do their own judicial review. Now Chevron is gone, so we'll see how much of this changed and how fast. I mean, as of last summer, courts have started to actually say what the law is. Not really. We're starting to see a lot more instead of deferring to agencies. And we saw exactly how that played out the other week when the court's ruling on President Trump's use of tariff authority in the specific legislation that he was using. At issue are questions about statutory delegation. Because if you looked at the ruling from that court, it stated because the text did not state revenue or taxes that they did not mean lesser or. Because originally the President Trump's administrative agencies were arguing that since it said embargo, that tariffs are lesser than an embargo. And so that was kind of really the first place we saw of the effect of the Chevron doctrine. Now, can the president leverage existing trade statutes and emergency economic powers to place tariffs on nations that have trade deficits with the U.S. or otherwise take actions that harm the U.S. economy? Well, in this instance, they said no. I mean, obviously, opponents of tariffs say this stretches the delegation language too far, and proponents say Congress very clearly intended to give the executive latitude on matters of foreign trade and national economic security. That's not to say they didn't, but not in that specific legislation. There's 3 or 4 other pieces of legislations that actually state the word tariffs or revenue in them. So, which I can't remember all the sections, like section 151, 232, and 332 or 304, something like that. What's important about this back and forth is how it will be decided. Pre-Chevron courts would likely have deferred to the executive branch's interpretation of its own authority. Post-Chevron, they're asking a new question. What does the law say? Now, not what the agency thinks it says. What does the text of the statute actually lay out? That matters. It doesn't, because statutory interpretation is where power resides. If agencies are given leeway to interpret their own authority, they accumulate more power. If Congress passes vague bills that allow for broad interpretation, agencies accumulate even more power. But if courts say not so fast, if courts take a strong view of textualism and insist on sticking close to the exact words of what Congress wrote, that takes power back. And that's what Congress haven't wanted to do for years because of the fact that they don't want to deal with the political hot potatoes. Now, you might ask, where does that leave administrative law in general? I'm glad you asked. And Philip Hamburger has written a great book on just this subject. It's called, Is Administrative Law Unlawful? Obviously, he thinks it is unlawful. That's kind of the whole point of the book. Here it is, Hamburger, on the primary problem with administrative law. One of the quotes is, administrative law is the power to bind Americans without representation. Pretty strong language. Also, Hamburger goes into a couple other ones, and I'll get those. But Hamburger has devoted years of study to this topic, and he's pinpointed the core conflict with administrative law. When unelected bureaucrats can issue rules with the force of law but are not directly accountable to voters, there's a problem of consent here. Aren't we supposed to be able to are governed by our laws that our elected officials create so we can unelect them? When agencies get to both create and interpret those laws, where does the consent of the governed come in? Hamburger also points out that the rise of administrative power is a return to forms of prerogative power the Constitution was designed to forbid. Now, if anybody doesn't know what prerogative power is, that goes back to the monarchy and the kings and the star courts back in the 1500s and 1600s. Administrative governance was not overlooked in our Constitution. It was specifically the founders experienced it at the hands of the British and did not agree on it. And they purposely crafted a government that prevented anyone from amassing too much power. As Hamilton explained in Federalist number 48, there is no liberty if the power of judging be not separated from the legislative and executive powers. If the agency has the power to police its own regulations, that's judging. Congress writes the laws. Agencies shouldn't be able to decide what that law means. We are seeing this play out with the president and his tariffs, and we're also seeing it in other ways. can the executive branch generally claim the authority to place tariffs based on how they're interpreting their own delegated powers? Or will the courts say that Congress didn't clearly give them the power, which we know that they did in that specific instance for that piece of legislation? And obviously that's going to have ramifications on executive power in that instance, but we'll see how much further it goes. Not only with tariffs, but any number of economic tools at the president's disposal. Does he have unlimited authority to control commerce as long as Congress leaves its statutes open-ended? Or will the court say Congress delegated too much power and draw a line? One way or another, the lines of separation are about to get drawn. Whether they're drawn in the right place remains to be seen. But at least we can have courts that are willing to draw those lines again and force Congress to actually do their job as they should. Now, because the administrative state is truly the gulag of the regulations, slow-moving, inefficient, and wholly unaccountable to the people, which we've seen that too many times, too many different ways, no wonder President Trump time and again takes aim at their power. Trump may not have been an originalist president, but when it comes to administrative power, he's unequivocally taken us back to our founding principles. Federal power must be limited, and it must be clearly defined. This is getting to the unitary executive theory. And anything less just opens the door to tyranny. Segment 5, I'm going to take a break, and I'm going to get a drink real quick before I start segment 5. And it's getting into here with presidential power, I'm getting to the part of the unitary executive theory and power. And one of the reasons it pushes for that is then it will force Congress to actually start doing their job. And because what happens in the administrative agencies is when the people within the administrative agencies are not beholden to the head executive, the president can't fire them. Then if they decide that they don't like the policy idea the president's trying to implement, they can just slow walk any of the studies and any of the stuff so that policy doesn't get implemented. But that's not their job. They weren't elected. The president was elected. Now, over half of the people of the United States elected him to be president. Obviously, the other half may not agree with his policies, but half the country does. So some unelected bureaucrat that's worked in that position for 30 years doesn't get to decide who gets that power and whether something is implemented or not. Now, so let's get into the presidential power and independent agencies, which is one last area of structural tension, the most consequential of them all, perhaps. Executive authority in particular, whether members of the executive branch may or may not remain independent from the president. Because if you're okay with the administrative state, and again, I'm not, we have to ask ourselves, who's running it? The executive power shall be vested in a president of the United States of America, not in agencies. I mean, that's a pretty clear starting point. It's not plural. It's singular. It's not shared. It's not divided or anything like that. It's not in part delegated to independent agencies. It shall be vested in the president, not 20 million different agencies. And so notice the word choice, vested. Under originalist interpretation, the vesting clause enunciates what we refer to as the unitary executive theory, the concept that all executive power is ultimately exercised at the president's pleasure. Why does that matter? Well, the administrative state wields massive executive power. Administrative agencies enforce laws. They investigate, which they shouldn't be. They also prosecute wrongdoing. They create policy. I mean, how are they creating policy? Legislature creates legislation and policy. That's executive power too. So when you have agencies wielding executive power but insulated from presidential control, you create a situation in which executive power is exercised without executive accountability. As Justice Scalia called out directly in his Morrison v. Olson dissent when he said, "This wolf comes as a wolf." He's speaking of the independent counsel. He understood that if you accepted the existence of executive power outside the president's direct authority, you compromise the entire structure of our government. Because when you have power without accountability, you have unconstitutional power. Now, opponents of the unitary executive will say, but these agencies have to be insulated from politics. They have to be independent from the president's control. But the Constitution is not concerned with whether government is sensitive to politics. It's concerned with whether the government is accountable. Alexander Hamilton explained this notion in Federalist number 70 when he said, a feeble executive implies a feeble execution of the government. But more importantly, energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks. It is not less essential to the steady administration of the laws. But in whatever manner this energy may be conveyed to the executive, it will always be safer whenever the executive is accountable to the people. He will always feel in caution and restraint who knows he may be called to answer his conduct at the bar of public judgment. In other words, when there's one person holding all the executive authority and that person is elected by the people know who to blame. But when the power is fragmented among dozens, if not hundreds of agencies, boards, and commissions, no one is responsible. And that's not an accidental byproduct of the administrative state. That was the whole effing point. Which brings us back to why this matters. Critics of unitary executive theory often say, well, hang on, don't you think you're giving the president too much power? See, that's a great question, but a lot of that power was given to the president by Congress. But it actually illustrates the point even better. The issue isn't the president having too much power. The issue is that the executive branch already has too much power itself due to all the administrative agencies, and Congress gave it to them. The president didn't take it. Congress delegated its legislative authority to administrative agencies. So when Congress writes vague, broad statutes and allows the agencies to make the tough calls and actually write the full legislation, why do they do it? Well, it's easy why they do it, and it's pretty common sense. They don't want to be accountable for their decisions. They want to let some unaccountable bureaucrat do it. But our constitutional structure doesn't allow for that delegation unless Congress is willing to accept the consequences. James Madison famously said in Federalist Number 51, ambition must be made to counteract ambition. The structure of our government forces the branches to compete with each other to maintain their authority. But when Congress is content to willingly give up its power, that competition no longer exists. So here's the deal. If we're going to allow the administrative state to exist, and we have the unitary executive, isn't just one theory of constitutional law. It's the only way to administer the administrative state cleanly. And you may ask, why is that? Well, it gets back to what we've been talking about. The alternative is that we actually have a fourth branch of government, one that's not only unelected, but largely unaccountable and not clearly laid out in our Constitution. And remember, when the Founding Fathers drafted the Constitution, they did not design 4 branches. They designed 3. So now here's where it gets really interesting. And this is what creates tension with the court taking too aggressive a stance on unitary executive theory. The administrative state allows Congress to delegate authority, not unlimitedly, but it allows them to do it, to effectively create laws without having to write them clearly. To delegate blame if something goes wrong. Oh, they did it. I didn't do it. But if the courts reined in the administrative state by forcing Congress to lose that ability to hide behind agencies, you can bet Congress will be forced to do something they failed to do for the better part of 80 years. They will be forced to actually legislate, write better laws. And obviously probably won't get very many laws because Congress today can't decide whether the sky is blue or green. They can't decide on which leg to put the pants on first. That's just Congress for you today. So probably wouldn't get that many laws, but they would actually be forced to truly write laws. Because see, today when they write what they call a law or a piece of legislation, it's not truly legislation. All it is a small statute that says, hey, this is what we'd like to happen. Doesn't say how it's supposed to happen, just says we'd like it to happen. And then it either defers that to the Department of Homeland Security, Department of Housing and Urban Development, Department of Energy, Department of whatever, to actually draw up, conduct studies and draw up the whole policy to actually implement the full law, that what people actually have to follow, the published law. Or if it's state levels, they'll say, hey, we would like you to get these, we would like you to meet these certain things in order to get money. And then you've got this time to do the study to get it back to us. And that's what they do. So they have to define the terms clearly, own their own decisions. In other words, fixing our executive would help fix the legislative branch as well. Because the separation of power doesn't just prevent tyranny, it forces responsibility. Hold on one second, please. I just my little one's knocking on my door. Okay, sorry about that. My little one was telling me his brother wouldn't play with him. Lastly, this all ties back to today. The Supreme Court is going to increasingly face cases that challenge the limits of the president's removal power, the limit of the president's ability to control executive officials. If the court continues to endorse strengthening the president's removal power, it won't just impact the EPA, it'll impact everybody. So we've got to get this done. And I'm sorry, I've got to send it. I got to. All right, sorry. Consider what we've talked about today. The Constitution does not promise us a small government, but it does promise us a structured government. If we violate that structure, then we continue to allow the administrative state of state to grow in ways that our founders neither anticipated nor accommodated for. Then what we have isn't government of the people, by the people, and for the people. It's an administrative government. And that's what it's been grown to, and that's what Trump's trying to reverse. It's administrative government of bureaucrats, by lobbyists, for lobbyists, and for special interests, not for the American people. And we see it growing as that as can be. So this is getting to the segment 6. And then I'll be getting into the main intro real quick. I'm going to take a real quick break. Just a second. I got to let my kid unlock, and then I'll be right back. Just about 2 seconds. All right. Sorry about that, guys. All right. So usually I have my co-host with me, so my little one gets in, I can go take care of him whenever he's doing his section, and that kind of was not happening today, so I had to get up. But on our 6th and final section, executive orders and federal policy, this kind of going back to what we talked about earlier with California, and also going on the gender thing. So I want to talk about executive orders and the limits thereof. Can an executive order properly set federal policy on issues such as sex versus gender? Well, at the federal level, recently, we've seen an attempt to create a neat binary definition based on objective biology that would be applied to passports and other federal documents. One side is claiming this is just reading the text of the statutes and returning to the original meaning. The other side claims it's executive overreach. But constitutionally speaking, does the executive branch get to decide what the law means, or are they making new law when Congress refuses to act? Which also leads to another point we've touched on several times tonight. What are the proper limits of each branch of government? If Congress doesn't give us clear direction, where does the executive branch get to step in? And who gets to decide they overstepped? So, I mean, literally all they're doing is, when they're writing that, the Constitution is based off of sex, not gender identity. So it's kind of obvious that that would be in there, and that there's no choice on that. But of course, we've got this overexpanded government, this administrative state that's totally illegal. Needs to, obviously, we're not going to get all taken at once. The education department could be the start. Trying to get President Trump using the unitary of executive theory kind of forces Congress to go back and actually start writing their own legislation and writing true legislation and not putting it off. Because what happened was, back after World War II, obviously during World War II, a whole lot more agencies were made to take over the economy during the war. And whenever the war ended, instead of destroying all of them, they renamed them and made them as oversight. And then they also decided, oh, wait, legislation is getting too technical. These industries are getting too technical. We're not specialized enough in each one of these industries. So we're just going to create an industry and hire people that are for that. And then we're going to leave it up to them to make the policy and legislation. But that's not what the Constitution allows for. And maybe as a small, if they would actually keep a board within Congress versus a separate agency, maybe that way they actually have to review the piece of legislation that they actually pass that goes to the president's desk is actually what's put into the law books, and is what actually is what we have to follow. And it was complete at that time, and they actually had to sign vote on the completed bill versus just a broad direction of, hey, this is what you should do. This is what we're trying to accomplish. Do this study to give us what you're going to do for the policy. Then that would be at least a step closer, because obviously a lot of people in Congress never even went to high school, or didn't graduate college, or they haven't worked as an engineer, or they haven't worked in it's totally different. So I understand the speciality when it comes to energy and all that stuff, but they still need to be accountable to Congress, and based on people can go after their elected officials for when stuff goes wrong, versus an unelected bureaucratic hired person that's been working there 30 years and then be held financially liable based on their policies that they can't even go to that they have no recourse for. It's ridiculous. So now, well, that about does it for tonight's episode. Before we go through, though, I wanted to return to the original question we asked at the beginning of the hour. Who governs? Because every issue I covered tonight, from executive authority to election law to parental rights to the administrative state, all points back to that one fundamental principle. The Constitution was designed to answer that question clearly. Power is divided. Simple as that. Authority is limited, and accountability is essential to our government. Without that, we have nothing. But we're in a battle right now to see if those lines will remain firmly drawn in the sand or washed away with the tides. And that's what makes these discussions so important, because this isn't just about legal theory. It's about the structure of government and ultimately the preservation of liberty in our constitutional republic, not our democracy, because we're a constitutional republic. Before we go, I want to thank all of you again for joining us tonight on No Kings on the Hill with Dr. Hill Law. If you haven't already, please be sure to visit our website at nokingsonthehill.drhilllaw.com, where you can find the links to our YouTube channel and all of our other social media platforms. Follow us so you don't miss any future episodes. You can also sign up for free access to our weekly blog, or choose from one of our 3 subscription levels to support the show. Subscribers get access to our Discord community, opportunities to engage directly with us, chances to be a guest host, and the ability to vote on topics you'd like to see us cover for the next show. And don't forget, we'll be broadcasting live for 3 days next week at CPAC on the Patriots Prayer Network. I'll be hosting this posting schedule on social media as the times are confirmed. We're expecting some major interviews, so make sure you're following so you don't mess that out. Also, let me know, people that have been watching this for a while, versus did y'all like it being more structured on the policy and the constitutional aspect of it versus the news aspect, or the just general what's going on in the geopolitics or whatever area? Kind of let me know. Or if you'd like me to cover any one of these subjects in more depth on the constitutionality or the Supreme Court president on it, let me know. Also, anything that me or Joe do on Constitution or legislation is not to be construed as legal advice or anything like that. It is based on our own personal opinion and professional experience. So, and while you are also checking out the Patriots Prayer Network, please check all the other Christian conservative creators that are on the network and their podcast. And as always, leave me your thoughts down in the comments and let me know what y'all thought. One more question. Do you believe the Supreme Court is reestablishing constitutional limits or rewriting them? I do want to hear your thoughts on that. Let me know. You can also leave a review on the website. Thanks again for joining me again tonight. I'm Dr. Hill, and this has been No Kings on the Hill. And I hope stay blessed, stay informed, stay poised, and I hope to see you on the Hill next Wednesday.